If I could ask the gentleman in the back to stop talking, thank you so much. Now, I'd like to welcome Matthew Goldstein. Thank you.
When I was a police officer, we had this saying. It was front sight, trigger pull. That doesn't have anything to do with what I'm about to talk about, but I was told that I had 8 minutes, and I just heard I had 10 minutes, so I got 2 minutes to play with. So my name is Matthew Goldstein. I am the chair of the International Trade and National Security Group over at the law firm of Faring and Medcoff in Arizona. I'm an ITAR guy. And I'm here to talk about the case of Defense Distributed and the Second Amendment Foundation and Con Williamson versus the United States Department of State. And to talk about the impact of the Department of State's application of the International Traffic in Arms Regulations, the ITAR, on gun-related speech that's protected under the First and Second Amendment. Now, the Department of State implements the ITAR to protect United States national security and foreign policy interests. And the ITAR, as many of you may know, prohibit or restrict the exports of defense articles from the United States. And a defense article that's items, software, technical data that's described on the ITAR United States Munitions List, the USML. And the USML has 21 categories of defense articles that are subject to control. The very first, Category 1 of the USML, is for firearms. And the Department of State knows, or it should know, that it cannot impose the ITAR as a prior restraint on public speech. Since 1978, the United States Department of Justice Office of Legal Counsel has advised the Department of State, the Department of Commerce, the White House, and even Congress that to impose a prior restraint under the ITAR or other export regulations on public speech violates the First Amendment. In 1997, in the wake of the Oklahoma City bombing, the Department of Justice issued a report to Congress about a proposal to impose a strict liability prohibition on the publication of bomb-making information on the internet. And the Department of Justice said, you can't do that. It would violate the First Amendment. So what changed? Well, in December 2012, a company out of Texas named Defense Distributed posted a variety of gun-related information on the internet. This information included CAD, computer-assisted design files, that can be used with a 3D printer to manufacture a high-capacity magazine, an AR-15 lower receiver, and a one-shot gun called the Liberator. What also happened in December 2012? There was the shooting at Sandy Hook Elementary. There was a tragic shooting in which a shooter shot and killed 26 people, 20 of which were children. In response, the Obama administration set forth an announcement of a very ambitious gun control agenda. A primary focus of this agenda was a ban on high-capacity magazines. Now, it's, as you can imagine, difficult to control high-capacity magazines when folks can just print them in the privacy of their home. And so it's within this background that in May 2013, the Department of State sent Defense Distributed a letter warning that it may have violated the ITAR because it did not obtain prior approval from the Department of State before publishing the information on the internet. It warned, it demanded that the company take down the information it posted online, and it instructed Defense Distributed to file what they call commodity jurisdiction requests with the Department of State, basically requests to the agency to determine whether or not the files themselves are indeed subject to ITAR control. Defense Distributed complied with every one of these requests. It took down the information, and it submitted the commodity jurisdiction request, actually 10 requests. After 2 years of waiting, there was no response. And so, Defense Distributed, the Second Amendment Foundation, filed a lawsuit in the Federal District Court for the Western District of Texas against the Department of State, the Directorate of Defense Trade Controls, which is the subordinate agency in the Department of State in charge of implementing the ITAR, and against various government officials for exceeding their statutory authority and for violations of the First, Second, and the Fifth Amendment. We were later joined by Con Williamson as a plaintiff. Our Second Amendment claim was based on our argument that the right to possess firearms also includes the right to acquire them, and that the most basic means to acquire a firearm is to make it. We moved for a preliminary injunction. The court denied our preliminary injunction. We appealed to the Fifth Circuit Court of Appeals, and they affirmed the lower court's denial of our preliminary injunction in a 2-to-1 vote. Now, in her dissent, Judge Edith Jones wrote a very lengthy opinion in which she adopted pretty much every one of our First Amendment arguments for why the application of the ITAR to public speech involving firearms violates the First Amendment. We filed a writ of certiorari for the Supreme Court review, which was denied, and the case was remanded back to the Western District of Texas. It's at that time that the court ordered the parties to exchange written offers of settlement. And we received a very favorable offer from the Department of State. It basically gave us everything we were asking for. So Defense distributed Second Amendment Foundation, and Con Williamson accepted this settlement, which requires the Department of State to actually amend the ITAR to remove its controls on the technical data in question. It also requires the Department of State to issue a license to Defense Distributed while the amendment was pending, and a notification of a modification of the ITAR posted online to allow all U.S. persons to share, contribute, and otherwise use and benefit from that information. In short time, Everytown and Brady organizations filed motions to intervene to stop the settlement agreement. On July 27, 2018, we went down to Texas. The court denied the organization's motion to intervene. And that same day, the Department of State issued the license to Defense Distributed, posted the temporary modification. It posted Defense Distributed posted lawfully 10 CAD files. They were complete CAD files for AR-15, AR-10, Colt 1911, other guns and guns parts. But within a few days, various attorney generals across the nation, blue states, filed motions to stop the publication. We had actions filed in New Jersey, Pennsylvania, and Washington State. We were able to obtain stays in New Jersey and Pennsylvania pending the outcome of the Washington State litigation. And in Washington State, we started off with 10 attorney generals. Now we're fighting 20 attorney generals, state attorney generals, including the District of Columbia. And they're arguing that the Department of State's actions under the settlement agreement violate what we call the Administrative Procedures Act, the APA. They have 2 points they raise here. One is that the Department of State didn't follow proper procedures under the Arms Export Control Act, which is the statutory authority for the ITAR. In that they say that there's a requirement that there be a 30-day advance notification to Congress before they issue this license to basically release this stuff on the internet, which they said is tantamount to a release of controls. I've been in ITAR. I've been working in ITAR for about a little over 15 years now, and I can tell you quite confidently they're wrong. The section they're talking about, Section 38F of the Arms Export Control Act, it doesn't apply to situations like we have. It doesn't apply to these license or modifications. Their second argument is that the decision by the Department of State was arbitrary and capricious. Again, they're wrong. The actual decision to transfer the firearms was not made by the Trump administration. It was made years ago as part of a larger export control reform initiative by the Obama administration. But plus, in a press release by the Department of State, they said the reason why they settled this matter was because the Department of Justice had told them that they were going to lose in court on First Amendment grounds. And that's pretty consistent with all the guidance the Department of Justice has been giving them since 1979. We presented all this information to the court, all the Department of Justice memoranda, even the report I discussed from 1997. The court still issued the injunction. The injunction is twofold. One, it says that the Department of State cannot issue the license and a temporary modification, but that was already issued and the information was published. So the court also held that we need to maintain the status quo, which really was the information was out there. But in the court's view, the status quo was that the parties need to treat the situation as if the license and temporary modification were never issued. And so what that meant was we have basically a takedown order. Defense Distributed was required once again to take the information down from the internet, and we now have a new type of censorship going on. The status of the case right now is that all the parties have filed cross motions for summary judgment. We're awaiting a decision, and it's a hard fight. It's continuing, but it's worth fighting for. Thanks.